At this point, are we aware of what some of those larger differences or specific requirements of the DPDP Act could be?
Yes, we have an overview of it. The main difference, of course, is acts around the world do not really demarcate between data kept in a physical form versus data in a digital form. But in India, the law only applies to personal data when it's in a digital form. So when it's captured digitally or when it's in a physical form and then scanned or put into the system and subsequently it's digitized. These physical files, papers, file system, they don't fall under the Act, which is different. Similarly, under the Indian Act, publicly available data is exempt from the provisions of the Act, which is something different. The legal basis in India is mainly consent. So you do need the individual's specific, affirmative, unconditional, unambiguous consent to process data. There are some exceptions to it, but those exceptions are quite limited. In other legislation, for example, GDPR, you have a lot more grounds to process data. Another interesting concept under the Indian Act is something called a consent manager. So the Act does provide that there can be tools, interoperable platforms that can be used by an individual to manage giving consent, withdrawing consent, managing their subject access requests, and so on and so forth. The Act itself provides for it. So this consent manager would act as an agent of the individual and will be registered with the Data Protection Board. That's something different. Data localization is different. Data transfers are treated differently under Indian law. The government is going to publish a blacklist, a list of countries or regions where data cannot be transferred. So that is different. Individuals have different rights in India. So there is one more right for us called the right to nominate, where we can nominate another individual who can exercise our rights on our behalf if something happens to us. Children's data is protected under the Act in a very strict manner. You can process children's data only with consent, and you cannot do targeted advertising or behavioral monitoring of children. So these are some of the important differences. Some other compliance requirements that are different. There is an independent data audit that certain companies would need to do, which is quite different. Many laws around the world provide for a DPIA, a data protection impact assessment, but the Indian Act specifies that there needs to be an independent auditor reviewing compliance for a category called significant data beneficiaries. So these are some of the things that are different from the other legislation.
I think the other set of questions that we typically receive, Akshay, around the different legal structures of companies across the world, and how does that impact the compliance to the DPDP Act. So, for example, if there was a parent holding company with an Indian subsidiary entity and they're only employing Indian citizens, and they obviously have all the personal data of those citizens, but they might not be having an application which is essentially, let's say, collecting data of Indian users, for example. So would some portion of the Act be exempt for them, or would they be exempt from the Act altogether? I think it'd be useful to throw some light on how a corporate structure would impact the relevance of the law itself.
So there would be two aspects to this. One, the corporate structure is such that there is a group entity outside India that is collecting data of individuals or their group company in India, employees, so on and so forth. And the converse, where there is an Indian entity that is processing data of the staff of their foreign holdco or directors of foreign holdco or customers of the foreign holdco. So in the first scenario, where there is, say, a US headquartered group, which is collecting data of its Indian subsidiaries, employees, or staff. Since this activity is not related to selling something to individuals in India, the Act will not apply in this scenario. However, if there is a US holdco which is using individuals in India to market their product, to sell their product, or do any sales activity, then the Act will apply to such processing. Conversely, where there is an Indian company which is part of a multinational group, and let's say the shared services are in India, or the operational headquarters is in India. So you have an HR team in India that has data of employees of the group around the world. You have a sales team in India that has data of leads or potential customers around the world. There again, you have to see whether you are processing data of non-residents just for the benefit of your parent company outside India, or are you doing it for you? where you are just acting as an outsourced entity, something like a BPO, where you are just helping out the group company, but you're not really doing anything for yourself, then you will be exempt from certain provisions of the Act. For example, you don't need to get consent from that individual. You don't need to respond to those individuals' access rights. It would be the entity that's actually collecting data that will be responsible for it. So there will be an exemption of application of certain provisions of the Act if you're an Indian company processing data of foreign individuals under a contract you have with a company outside India, like an outsourcing contract.
And in such a case, would there have to be some kind of a agreement between these two to actually, protect the BPO or the subsidiary company from the risks, and the risks are actually transferred to the parent holding organization?
Absolutely. So the contract will serve a couple of purposes. The main being clearly defining the scope, that this data is sent to the Indian entity under a contract, and it is for the purpose of doing something for the foreign entity. So that should be ring-fenced clearly, and as you said, it should also allocate responsibilities and liabilities. So that intergroup contract becomes very important.
Understood. So is there an equivalent of, the GDPR calls this the data processing addendum, which needs to be executed between such companies? Is there such an equivalent for the DPDP Act as well?
That's an excellent question. So a DPA under GDPR is necessary for a controller to engage a processor. So if you are collecting the data, or if you decide the means and methods of collecting personal data, and then you're appointing someone to do some part of the job for you, then you're appointing a processor. And under GDPR, you can appoint a data processor only under a valid contract. The contract has to have mandatorily a couple of things, and both the controller and the processor are going to be responsible under the Act. Now, under the Indian Act, the data fiduciary who plays the role of the data controller. So the data fiduciary is the entity that's deciding from whom I should collect data, for what purpose, what data, so on and so forth. The entire burden of compliance is on the data fiduciary. They have to enter into a contract when appointing a data processor, but the Act does not say anything other than that. So what needs to go into that contract, whether mandatorily something needs to be mentioned, is not there in the Act. What it does mention though is that the data fiduciary is going to take responsibility for the data processor. So it's very important to make sure you are signing strong contracts with the vendors you engage.